Right, good morning everybody. Welcome to today's EM Law Share training session. As the title suggests, what we're proposing to cover this morning are hot topics for local authorities in the time of coronavirus. And your presenters today are myself, Nathan Holden, who leads Freeths local government practice, and Stephen Pearson, who leads on the public sector contracts primarily side of things, and as well as other things. So how we propose to deal with today's session is to take you through a couple of the main topics that affect local authorities in the context of the coronavirus. And I've set them out there: issues that relate to EU procurement regulations, the very topical issue of force majeure clauses, state aid, which of course is a topic that's floating around or thereabouts most of the time, and of course has been brought into sharp focus given some of the aid measures that the government's introduced. Some issues around enforcement of business tenancies, which is really about just being up to date on the law. A little bit on electronic signatures, and some other practical issues that we've noticed or have arisen in the last 3 months. And then finally, we'll round up with some questions with the aim of finishing at around about 12 o'clock. So, right, what I'm going to do now is I'm going to pass you over to Stephen. I shall mute myself and let Stephen carry on.
Yeah, fine.
So I've just muted you, Stephen. Oh, sorry, Stephen, I just muted you.
Okay. I hope people can hear me now. We had a few last-minute technical issues. Nathan will be moving the slides on, so it's going to be like those government press conferences that we all know and love, where we say, next slide, please. But yes, I'm going to talk about the scope of the procurement regime, and then going on to a particularly topical issue, which is the contractual clauses, and particularly force majeure clauses, and how they're affected by the current coronavirus situation. So next slide, please. Yes, it works. So procurement rules, what procurement rules? I say it slightly tongue-in-cheek. They're obviously, for those who don't have a very big screen, is the XL London, or now the Nightingale Hospital, which obviously was built within a period of, I think, something like 7 days. Fortunately, it hasn't been used very much, so it does lead to questioning how you can do a major project within that period of time, given the time constraints that procurement rules exist within. I did see an article after putting these slides together which suggested that actually it was all done properly via call-offs from NHS procurement frameworks. So I'm not saying that there was a particular breach of the rules in terms of this hospital, but I think it does fall into question how we cope with a quite monolithic set of procurement rules, given the fast-moving environment that we've all been subject to over the last few months. And next slide, please, Nathan. Yeah, and so that's a headline from The Guardian from a few weeks ago. Obviously, there have been concern about procurement rules not being followed, and that headline was really about central, I think, rather than local government, that firms were given something like £1 billion of state contracts over the last few weeks without tender. And it's been stated that ministers have been told, I think, by the Cabinet Office not to use coronavirus as a blank cheque to evade accountability. And clearly that is the risk, and there will be a reckoning at some point, I think, if rules are not followed. And I think to the extent that there are exceptions or what might be called loopholes within procurement, that they are properly dealt with, that there is some contractual cover, some legal cover for what you are seeking to do. And I think, and this will be a theme through my talk today, that there needs to be an audit trail, there needs to be accountability, or otherwise there will be a long-term reckoning when people start paying the bills for some very expensive contracts that are going out at the moment. Next slide, please, Nathan. Thanks. So some of the money that's being spent is frankly quite boggling. We started off a few months ago, if you remember that, with Rishi Sunak there committing £60 billion of budget spending to issues related to coronavirus, which at the time people thought was a large amount of money, but now feels like a drop in the ocean. There are now £330 billion of loan guarantees. There are obviously the network of Nightingale hospitals around the country. And interestingly, I think a civil servant conscious about his accountability sought a formal ministerial direction, because obviously the Department of Health, and I'm sure MHCLG is no different, is subject to quite tight financial constraints arising from years of austerity, and now the taps have been opened. And there's a copy of the ministerial direction from Matt Hancock as Health Minister, where he formally confirmed to the civil servants to direct them to continue spending well in excess of formal departmental expenditure limits. And I think that kind of sets out the background of where we are. The traditional rules about austerity seem to have been, for understandable reasons, thrown out the window, at least for the foreseeable future. Next slide, please, Nathan. And obviously for local government, there's been, I think, a strange game of catch-up going on where national government allocates local government some money. Local government says this really isn't enough for our purposes. We need more. You think of issues about aid to local industry. You think about the costs of organising food packages for people that are under shielding. You think of the loss of income for things like, say, car parking, planning fees, rental income from authorities who are involved in the commercial property market, as a lot are. So you might have seen that, unfortunately, the leader of Spelthorne Council, the council renowned for borrowing, I think, as much as £1,000 million to get into commercial investments, left very quickly, and also left, I think, his local branch of the Conservative Party. So you've got the initial 1.6 billion. It's not enough. The further 1.6 billion on the 18th of April. Deferment relief for local authorities because of the loss of business rates, which obviously had been deferred, made loss of income, 2.6 billion. A hardship fund that can be accessed for COVID-19 generally at 500 million, £5 billion general response fund. Most recently, and I think quite topical in terms of what's been happening today, £50 million to reopen high streets. So that's things like signage, one-way systems, employing street wardens to tell people to keep their requisite distance apart. And also £600 million for monies towards infection control. And that includes things like going towards PPE. I know a number of local authority clients have told me that in building contracts, for example, contractors are saying we need extra funding for PPE, which sometimes is disposable and has to be used daily. So there's a big difference. Traditional local government money being raised through council tax and commercial rates seems to have been replaced by a lot of emergency funding. But these are all individual budgets that have to be applied for on a case-by-case basis. So next slide, please. So how can monies be spent given the limitations of procurement and contractual restrictions? We're going to talk in a little bit more detail in a few minutes about some of the recent purchasing policy notes and guidance that have been issued. But I think the message, sort of big picture, is that it is now deemed to be acceptable to have payment in to go away from perhaps the traditional payment in arrear model that you see within local government contracts. I was always taught in my days in local government that you get a service, you check that service has been provided properly, you then sign off that it's been provided properly, and you make a payment. The trouble is that may mean that it's 2 or 3 months between the service being provided and payment being received by the supplier, and suppliers just do not have the cash flow to justify that at the moment. The other thing I think we have is that the purchasing regime, rightly or wrongly, is quite time consuming. We're used to having supplier questionnaires, we're used to having tenders, we're perhaps used to having best and final bids to justify that the price is as good as it can be. And of course, a standstill period, the general period that we have of 10 days in terms of warding off and dealing with potential challenges. And I think a point that also has become very apparent in a lot of the contracts that we've been looking at is that either force majeure is not available, there isn't a force majeure clause within the contract, or it's not relevant. The way in which force majeure clauses are frequently drafted is they define force majeure to include things like inclement weather conditions, industrial dispute, storm, hurricane, something like that. But very rarely does the wording go as far as covering a pandemic and the government steps in relation to that pandemic. So I think if you haven't already, and I'm sure some of you will have done, it's worth looking at what clauses say within your contract, and even if force majeure is there, whether it's applicable. And of course, as a matter of general law, You cannot imply force majeure into contracts. It has to be something that's drafted into the contract to be applicable from a legal perspective. Next slide, please. So what do we have? We've had a plethora of guidance, I think, from the Cabinet Office going back over the last 2 or 3 months. In March, we had Purchasing Policy Notes PPN 120 responding to COVID-19. We had PPN 0220 about supplier relief due to COVID-19, which we're talking about a bit more. Over the last few weeks, even we've had PPN 420, which came through very recently, which talked about guidance to public sector bodies in terms of how to have to deal with recovery and transition from COVID-19, and they're certainly worth looking at. We've either had more generally, and this isn't just for the public sector, guidance on responsible contracting behaviour, which is quite a broad spread document which purports to cover contracting parties across the board. Some of these are interesting and relevant, and some of it, frankly, is flannel and not very helpful, I think, from a legal perspective. What I think is useful is within the guidance, and I think it's PPN 220, there are model interim payment terms that can be utilised in terms of allowing early payments under contract, which are quite a useful bit of drafting that can be put in to make sure that if you are making interim payments, you're doing it on a sound contractual basis based on arrangements that you have. Also arrangements in terms of contingent worker supports. So in terms of things like organisations and what local authorities do now, things like, say, the social work field, they employ people on an agency type basis that don't fall in normal furlough arrangements, and they might otherwise be regarded as simply being laid off. And there are provisions allowing for support for people like that. Next slide, please. So do these purchasing policy notes change the law? It's a difficult area because I know a lot of suppliers, particularly I've seen it in the leisure field, for example, are saying to local authorities, you have to do this, you have to make additional payments, have to be generous to us because PPN 0220, for example, says that you do. Well, no, we need to be careful here, I think. The law is European law, European procurement law, and the purchasing policy notes is guidance only. I appreciate we're in the transition out of the EU, but black letter law will always trump guidance. And I'm afraid some of the things within the purchasing policy notes, if you were to follow literally, could be an issue, both in terms of procurement and in terms of state aid. And I know Nathan's going to talk more about state aid, but just, as it were, handing out money willy-nilly, unless there is some support in terms of the state aid regime, it is a problem. Guidance is useful, but it's only guidance. Having said that, there is some, I think, quite useful guidance and help within, for example, PPN 120 that set out ways in which you can seek to deal with situations and work with those from a legal perspective. The first one is extreme urgency, and that's within public contracts regulations, Regulation 32. Now, that's the one that's called negotiated procedure without prior publication. So, insofar as strictly necessary, where for reasons of extreme urgency brought about by events unforeseeable by the contracting authority, the time limits for the open or restricted procedures or competitive procedures cannot be complied with. In that case, you can award a contract without prior publication. So basically, you just go ahead and award a contract. But, big book, the circumstances invoked to justify the extreme urgency must not in any event be attributable to the contracting authority. And I think also the reason for that extreme urgency has to be recorded. So I think there has to be a connection between the situation that we're in and the need for extreme urgency. So, for example, a contract is to do with, for example, buying PPE, taking some other special measures. It's not a sort of camouflage device that you can award any contract that you feel like without going through a competitive process because there's a pandemic on. But I think that is useful, but it has to be very genuine extreme urgency. But clearly, I think you can see that if there is a relevant situation, then Regulation 32 fits quite well, and it's good for the authority to record the fact that they're using that. The other mention is PCR Regulation 12 that talks about direct award. That I think is not awfully well explained within the guidance, but that's one where it talks about using the services of a subsidiary or another contracting authority. So that's a situation where perhaps you have a relationship with another local authority next door, you have a mutual support arrangement, and you can award a contract for services through that organisation. Now, the way the law is, as I understand it, that's supposed to be based on a proper contractual relationship, it's called a Hamburg relationship, following our case. It basically says it's part of inter-authority cooperation. It's not just a general open season to award contracts to companies owned by local authorities or to the local authorities next door. But clearly, that's worth thinking about. Accelerated timescales. Under the general procurement regime, you do have circumstances in which you do go through a process, for example, Regulation 27 and 29, where the usual period of something like 35 days to receive tenders is reduced to 15 days. So think about that. So that's the same process. It's just based on a shorter timescale. And guidance is given that within the ODU notice, there is some wording that they suggest that you put in. For example, the COVID-19 outbreak has given rise to an urgent need for the supply of these goods, which does not give the authority sufficient time to deal with it under the full procedure. So I think, again, useful guidance there. Use of frameworks. Interestingly, as I said earlier, the contracts for the Nightingale hospitals were I think, based on a number of contracts, particularly the NHS SBS framework, as it's called, in terms of works being called down. There are a wide number of frameworks available. If anyone wants to speak to myself or Nathan, we have lists where local authorities are permitted to join or can use frameworks for the purpose of handing out contracts. And those frameworks will frequently allow a direct award in certain circumstances or a very accelerated process in terms of awarding contracts for works, services, building works, certain sort of supplies. So worth thinking about. Also, contract amendment. As some of you might be aware, Regulation 72 of the Public Contracts Regulations 2015 do allow for quite substantial modifications to contracts in certain circumstances. And the guidance sets out very usefully that generally Regulation 72 can allow you to change the value, to increase the value of a contract by up to 50% in certain circumstances, where there are circumstances, for example, that you couldn't have foreseen what's happening, clearly the case here, and the modification does not alter the overall nature of the contract. So if you have a contract for certain goods or services, repair services for social housing, for example, you can have more of the same, but you can't have a different one entirely. Okay.
Sorry about that.
Okay, that's fine. And also exclusive rights. Again, this is something that's always been there. Public Contracts Regulation, Regulation 11. If there is an exclusive right that somebody has, for example, repairs to equipment that are going to be done by a certain supplier or repair agent, you can carry on with that. None of these points that I've raised actually represent anything different in the law. It's just really highlighting to contracting authorities that these legal situations do exist, and you can within the system move things around more quickly. Okay, next slide now, please. Yeah. So supplier relief, say PPN 220, I think is some quite useful guidance about how to help suppliers. There's clearly a major risk of people going bust, and I think that risk is going to carry on as we return to work and furloughing schemes come to an end. And this clearly, and I think some local authorities quite rightly are a little bit cynical about this, it seems to create a situation where the public sector is being requested to help out suppliers and stop them from going bust for the benefit of the economy as a whole. Whether authorities can afford to do that, I think, is a different question, but it's guidance. What it suggests is that local authorities in effect have a duty to identify suppliers who are at risk. It suggests that they should, as far as possible, I know this goes against the grain, to pay suppliers as normal, even if service delivery has been suspended. I think Nathan's going to touch on state aid, but really given the benefit of the doubt. To support cash flow by making payment in advance and interim payments. we talked about earlier, there is guidance about interim payments arrangements. So local authorities, I'm afraid, are not always the quickest people in the world in terms of paying, but it's saying, well, if you know you're going to get a service, pay in advance. If you are paying by results, for example, a number of contracts have key performance indicators, supplier has to meet the KPIs, they are signed off, then a payment is authorised. Now, that takes a period of time. The suggestion is you pay based on previous months. So you haven't seen this month's KPI results, but you pay based on last month's KPI results on the grounds that is a typical payment to make. And maybe you have an adjustment or a reckoning at the end of the crisis. And also, capitals, please, the suggestion is pay invoices immediately on receipt. And arguably, you should seek to be able to waive liquidated and ascertained damages and service credit regimes, which would otherwise reduce the amount of money that was payable. Clearly, I say this is guidance, and I think I'll take something with a pinch of salt, but it's suggesting really be generous, give the benefit of doubt for suppliers for the greater good of the economy as a whole. Some of you may think that's a jolly good idea, some not. But I think certainly the duty to identify at-risk suppliers is a good one. In my experience, a lot of organisations haven't. They have a large supply base. It's probably quite a big job to work out who is at risk and who isn't. A lot of people are at risk at the moment. Okay, next slide, please. PPN 220 goes on to suggest the necessary safeguards. We've talked about interim payment terms. Very importantly, keep an audit trail of what is being done and why. Insist on open book data from suppliers. For example, if suppliers are mitigating their costs, if they're not paying their rent and their council tax and their salaries, but they're asking for a full payment, that could seem like a super profit. The suggestion is that you may want to require relevant staff, perhaps that staff who are working with you, not to be furloughed to avoid double payment. Certainly at the start of the crisis, we were hearing things like large construction companies, for example, furloughing all of their white-collar staff. Now, some of those staff were people who are involved in servicing and designing the service for you. So, avoid double payment. And require suppliers to pay their supply chain. The point of you paying suppliers for items that they're not supplying for you is not so the boss can buy himself a new Porsche now that the car dealers are open again, but it's to keep the economy moving. So, look at conditions in terms of saying we are paying you only on condition that you pay your supplier chain in exactly the same way that we're paying you, i.e. promptly. And make it clear that where you are making a payment, that you have an ability to reclaim following the open book process if you subsequently discover that monies have not been spent by the supplier as required. The supplier has been keeping the money and not paying his own supply chain, his employees, etc., etc. And the suggestion is that there's a requirement to have what's called open book interim data. So actually require as part of these arrangements for a supplier to open up his book so you can see, the money is being spent appropriately. It is not simply being pocketed by the organisation. All this, I think, is very good advice, and it suggests that although you should be generous with suppliers, you shouldn't do that in a reckless way. Next slide, please. So PPN 0420, which came through earlier this month, and it's called Recovery and Transition from COVID-19. So it's meant really to be a continuity of what's in 0220. And to some degree, it repeats what's in 0220. For example, it says that all contracting authorities should have reviewed their contractual portfolio, looking at where they're providing contractual relief, continue measures in accordance with 0220, but to work in partnership to develop transition plans to exit from relief as soon as possible, including agreeing contract variations to ensure continuity of supplies, but to sort of move out from that total support package. Also, interestingly, and I think this is recognition that some suppliers frankly may not survive, to work in partnership with suppliers, openly and pragmatically, to ensure contracts are still relevant and sustainable, to continue to place suppliers as quickly as possible. But, sorry, we've gone too far forward. Back again. Sorry, we've gone too far there. One further forward again. Yeah. Now let's go back again.
Sorry, there we are. That one, sorry.
Yeah, but to pursue potentially a termination of contract, it could be that the supplier says we can no longer afford to carry on this contract. We're getting out of the business. We've lost the personnel. We've lost the unit. But to pursue in appropriate cases a termination, perhaps a mutually agreed termination, but to constructively engage as part of that contract. So you have a discussion to say that we're going to allow you to leave this contract early. And we have seen that in one or two cases. What has been said is that where central government money is involved, this is probably more based on central government departments and the Department of Health, but may also be relevant to schemes that are supported by national bodies like maybe Homes England, for example, that central government will make payments in advance of need. The normal understanding is that you get the money sort of potentially slightly after the event. This way they said that they will pay certainly a proportion of the money supporting contracts in advance. You have to apply to government and say, we're going to incur this contract cost. Can we have money in advance, please? That's slightly vaguely expressed, but I think is useful. Thanks. Next one, Nathan, please. Also, there's some very general Cabinet Office guidance called responsible contracting behaviour. I think it's been frankly quite cynically received as being rather more than apple pie, but it's seeking to say to all contracting organisations that they should seek to behave well and nicely to each other. But it's not just for the public sector. It talks about responsibility of contracting parties to be responsible and fair in their dealings, to give relief in terms of contracts, so not to be too pernickety and pedantic about contractual duties, contractual standards quite being met. And I think we're seeing this with quite a lot of authorities who are giving some, as it were, forbearance where suppliers, I'm aware that, for example, waste collection has often been not dealt with to the same high standards from outside providers. To allow extensions of time in appropriate cases, so where there is a strict time limit, and I think this is frequently the case, for example, in construction contracts where things have to be done by a particular time, if not you're into damages, to allow extensions in appropriate cases, to allow for the fact that the supply chain is disrupted, employee arrangements are affected. Good to see that when cases get to court, to what extent courts are going to look at this guidance, because it is very much across the board. To return deposits, I don't know if this includes the package holiday sector where there's been a number of issues, but certainly in situations where deposits have been retained, for example, or the security deposits, which tie up cash flow, then to seek to see whether you can return any monies that are being held with third parties, and seek to resolve disputes amicably. I think there's an eye on disputes that might be in the future, so actually to not adopt a very litigious approach, but to seek to resolve disputes between the parties. I said this is not particularly for the public sector and is across the board, but I think is something that is worth bearing in mind. Okay, next slide, please. And now really just going on from the government guidance to talk about how contracts cover the outbreak itself. We've been doing quite a lot of contractual analysis on behalf of public sector clients in terms of whether contracts cover situations like this well. And frankly, generally speaking, they cover the situation very badly. And perhaps nothing like this has been expected before. The first thing to bear in mind, as I said before, but it is a common assumption held, I think, across the business and commercial sectors, that force majeure is always there within contracts. Well, no. Force majeure is a protection that applies only if it's specifically covered within the contract. So, if it's not there, you can't claim for it. As I said before, where there are force majeure clauses, they'll frequently cover weather conditions, industrial disputes, but very, very rarely pandemics. What is relevant, though, we have seen, particularly in contracts that derived from the old PFI drafting, and this is still the case, for example, in terms of the Standard Form Leisure Centre contract that Sport England have promulgated, is that where there is what's called a specific change in law, that's a change that particularly covers the particular sector that you're dealing with, then that can allow a right to relief, and in some cases compensation in terms of lost income that the provider would otherwise be receiving. What you have to do, though, is you have to relate that ability to claim for a particular change in law that in some way highlights this particular industry and doesn't say to the world as a whole, you can stop trading. And now we've looked at this in terms of leisure, for example, as a good example. The health protection coronavirus restrictions England regulations 2020 do have a schedule at the back of them which lists a number of things that have to be closed, and those things include gyms, indoor leisure centres and swimming pools. So clearly that can be called out as a specific change in law that entitles compensation based on the loss of income, because the law that's changed is the law that says you must close, and therefore compensation would seem to follow from that. And a number of outdoor facilities, I think it's not just leisure centres, have been subject to that. I mean, interestingly, it also relates to certain markets, so I don't know whether market traders might be thinking about using that. What about the recovery phase? What we have been seeing is a number of suppliers have been saying to local authorities, we have an amending agreement allowing us compensation for a change in law, but also we're expecting ongoing compensation, as is frequently the case now. Services are coming back up to their normal frequency, so there's a period of time where the income is 25-50% of what it might otherwise be, and they want compensation for that. Well, my reading, strictly speaking, on the black letter law is that once that change in law is no longer a change in law, so that regulation is rescinded or repealed, or the government says it's no longer going to enforce it, then there is not a strict legal requirement to compensate people based on their loss of income getting back up to the norm. And frankly, it's going to be a difficult figure to calculate, because different industries will, I'm sure, recover in different ways. Looking at department stores opening today and that sort of thing. So in agreeing variation agreements, which we've seen with quite a few clients, allowing payment to cover this change in law situation, I think be careful, authorities out there, not to open too much of a blank check in terms of compensating for a loss of income going forward. I think the economy is going to be in a different place, and some industries are not going to bounce back very well, but it's not affordable for local authorities to cover all of that cost, I think. Next slide, please. So how should forfeiture clauses be amended? It might slightly be regarded as looking the stable door after the horse has bolted, but there is talk about a second spike in terms of COVID-19, and who knows, there could be other epidemics in the future, who knows. So I think in terms of drafting contracts or amending them now, I think for all of us, we do have a standard clause that we're using, as you might expect, and if people want to talk to myself or Nathan afterwards, I'm sure we can help with that. But a recommendation is that you have force majeure clauses in your contract. They refer specifically to epidemics and pandemics, but also outbreaks such as this one, but also actions taken by government in connection with that. So, of course, the loss of income in some industries is not caused by the pandemic per se, but more the government changing the law to say that certain places can't open. Consider broadening the effect of the force majeure clause so that it covers not only where the performance of the contract has been prevented, but also where it's been hindered, prevented in part, or being made more onerous. You think of a lot of sectors now who are going to work in a different way with 2-metre distancing. Consider broadening the range of consequences. For example, include the ability to cancel individual orders or postpone fulfilment, as well as simply suspending obligations or having the right to terminate. So it may be that, if there's a range of services going on, you say, we will not say that you're in breach of contract if you don't supply this particular element of service because you can't, because your staff are furloughed because of a situation. And consider providing clarity as to the effects on payment obligations. For example, are you still obliged to pay for a service during suspension or not? Going on from the guidance, it may be something that you simply say, well, no. But I think it's worth thinking about. Okay, next slide. There is one. Yeah, just quickly before I wind up, possibly we've gone slightly over time. What about consumer contracts? Predominantly, of course, local authorities aren't involved in contracts with consumers. But I think it's worth thinking about, because we've come across a few situations where public sector bodies have said, well, we cannot provide the service that we were previously providing. Can we get away with this? In the education sector, some of you might be aware, of course, that universities are closing or not providing their usual service. That would apply to some colleges as well and schools. In terms of leisure users, you think of a number of leisure centre users have a subscription. They join a leisure club as part of the local authority, and clearly they would have been paying for a service that they would not been able to to receive at the moment. We have come across situations where individuals have been quite savvy about the Competition and Markets Authority guidance and the Consumer Rights Act 2015. That act is quite a useful bit of legislation, but what may be worth looking at for people who are dealing with consumers, service users in local government and elsewhere, is that there is a list within the schedule to those regulations of unfair terms, and they are terms which are generally to be regarded as unfair. Not automatically, but generally they may be regarded as unfair. And if somebody were to go to court about those contract terms, then they would have a strong argument. And one of those is the ability to alter the terms of the contract unilaterally without a valid reason. So if, for example, your leisure centre user says, I want 3 months worth of my membership fee back, and you say, no, we're going to change the contract to say that we can actually suspend your leisure contract without payment when we wish to, that would tend to be a problem. So just something that's worth thinking about. Okay, I think that is me done. So over to Nathan. Nathan, are we getting questions at the end, or how are we going to do it?
So yeah, hang on a minute. My slides seem to have a life of their own. Yes, well, I think it's probably best we take questions at the end, if that's okay. Okay. I think Stephen, if you could. You can hear me okay, can you?
Yeah.
I might just do this for a second. So I'm starting my video. You need to mute yourself, Stephen.
Okay.
That's it. And your image.
Sorry.
Yeah. Okay. Thank you, Stephen. That was very interesting. Interesting. What I'm going to cover for my own part, if I can move the slide on, is primarily state aid, as I mentioned earlier, and a couple of other topics that sit around it. State aid is an interesting subject to talk about in the context of procurement, because in a sense it's the twin of EU procurement. There are two measures by which the state tries to control the way in which member states affect the economies in which they run and operate. One is by virtue of the procurement rules to require all public contracts to advertise, so there's a level playing field across Europe. And the other is to stop state subsidy taking place. A state subsidy, of course, has the same effect as effectively awarding contracts on a softer basis. So it's the second tool in the box, as it were, or the other tool in the box that's relied upon to stop states from abusing their position to support their own domestic industries. And the definition of state aid comes from the Treaty on the Functioning of the European Union, and I paraphrased the relevant provision, which I think is Article 107 presently, which is that any aid granted by a member state or through state resources in any form whatsoever which distorts or threatens to distort competition by favouring certain undertakings or production of certain goods, insofar as it affects trade between member states, is being incompatible with the internal market. And what this gives rise to are four basic key factors that you take into account when determining whether or not there's a state aid is present. Number one, whether or not there are state resources involved. Do the use of those state resources favour certain undertakings? Undertakings means an economic operator in the market, not necessarily the nature or form of the entity that you're providing the funding to. Does this have the potential, and the key word there is potential, to distort competition? And does it also have the potential to affect trade between member states? And there are four key components. If you satisfy all four of those components, then it's likely that you will have a situation where state aid is present. Now, of course, as most of you will be aware, the UK has now left the European Union, and we are presently operating transitional arrangements, and those transitional arrangements end on the 31st of December 2020. And this gives rise to a rather interesting position in relation to state aid. In contrast to public contract law, that which is governed by its own set of regulations which are transposed into UK law, all of the EU law comes via Europe by virtue of regulations which are effectively directly applied. And what this means is that as of the 31st of December, there won't actually be any law, as it were, that applies to the UK in relation to state aid, other than by virtue of the withdrawal agreement, which makes provision for the imposition, or it makes provision for circumstances where the European Union can still enforce breaches of state aid that have occurred before the transition period ends. So whilst we're in this sort of interregnum, this sort of purgatory, as it were, between having left the European Union, having formally no longer any connection with the European Union, there is means by which the European Union can still enforce the provisions and can do so for up to 4 years after we've left, or actually the transition period expires on the 31st of December. Which is interesting because, of course, the normal limitation period for people who want to challenge decisions made by states is actually 10 years, not 4. But what this does is actually shorten the period in which they can take, or the European Union can take, enforcement measures against country, the UK, if it's believed that it's transgressed the public contract, the state aid rules. So we are in a strange situation. And then you may ask, well, what happens after the 31st of December? Well, currently, no one's entirely sure. It's believed that there will be some kind of domestic state aid regime so that one region doesn't attempt to favour another. So, for example, you don't have a situation where Scottish state or Scottish government attempts to favour Scottish enterprises as against English enterprises. So there will be something that replaces the state aid regime, and for international reasons it's likely there will be something, and we will potentially fall back on the World Trade Organization state aid provisions, but they are very much a softer version of the state aid rules we presently have, and so it's unlikely that we would resort to those in full, and it may be that we will attempt to come up with something that sits somewhere in between those and the arrangements we currently have. So, as I say, state aid is going to be with us for some time to come. I don't think it'll disappear completely, but it is very, very uncertain as to what happens after the end of December this year. Now, what sort of examples do we have of state aid that exists? Well, there are many. You have tax holidays, for example, so no actual money transfers or changes hands here. You have guarantees for loans. Again, there is no money changing hand, but just a promise that's made by the state to support a company in the event it doesn't comply with its loan obligations. And then, of course, you have the more traditional and classic idea of state aid, where you have some kind of direct grant being made to an entity. Now, not all aid that's provided by the state is state aid. State aid only applies where you have some kind of selective advantage being conferred on a particular economic operator. So, for example, if the state decides that it's going to give everybody a tax holiday, then that isn't state aid. If it decides it's going to subsidise wages that's paid to everybody in the economy, say, for example, like the fellow scheme, that too is not state aid because that's across the whole of the economy. Reduction in VAT rates that we pay, or business rates for everyone, and likewise is not state aid. So you have to be careful that not just because money is being provided by the state, that doesn't constitute or will constitute state aid. There has to be some kind of selective advantage, some benefit that's being conferred on an economic operator in order to assist them as opposed to others. And that's the key component of state aid, this idea that individual operators or undertakers or part or sector of the economy is being favoured by the use of state resources. So how does the coronavirus impact on all this? First of all, it's worth remembering that it doesn't actually change the existing rules on state aid. And when you come to analyse whether or not state aid is present in an individual set of circumstances, this is the mechanism by which you follow. I'll talk a little bit later or shortly about the coronavirus arrangements, but let's pretend we go back, say, 3 months and just look at the position as it was then and then compare it. So first step you would take is you'd have to determine whether or not there were state resources being used, as I've mentioned. So you have to work out, is this measure state aid? And in doing that, what you do is you look to see who benefits from the aid. Are they operators in the market? And if you decided that you could argue that this was state aid, that it was benefiting a particular economic operator, then you'd come to the conclusion that it was very likely that state aid was present, that there would be some benefit being passed on a selective basis to a particular economic operator. Now, if you reach the conclusion that that's happening, what you then do is look to see whether or not one or more of the block exemptions applies. Now, the idea of the block exemptions is it sets out a set of prefixed arrangements or circumstances where state aid is permissible. And these fall into a variety of different categories. So, for example, regional aid is a means by which the state can deploy resources to promote its economy in areas which are economically disadvantaged. And there are other circumstances. So, for example, aid can be given for historic reasons, for promoting history and the protection of or environmental reasons. There's a whole host of them. There's a long list of categories that might apply. And if you don't fit within any of those block exemptions, then the port or the place of last resort is, of course, to look to see whether you fall within the de minimis regulations. And these permit aid for any purpose up to a maximum of €200,000 over 3 years of the recipient's last financial 3 years. So therefore, you look to this financial year or the balance of it and 2 preceding financial years, and you tot up how much state aid has been given. And as long as that's less than €200,000, then that will be permissible. The €200,000 calculation is made by virtue of a changing, fluctuating exchange rate, which is calculated on a monthly basis, and then you can find it on the Europa website, and you just put in the figure, and it will give you the calculation for that month. This is different, of course, to the public contract regulations. They're calculated every 2 years. The last time they were fixed was the beginning of this year, which was in 2020. And then again will be fixed again in 2022 for those countries to which they still apply. Now, of course, if none of these categories apply, so if you can't argue it's not state aid or you don't fit within one of the block exemptions, then you have to apply for clearance from the European Union. And of course, given it's the European Union, that can tend to be quite a lengthy process and involved. And I think the general consensus is that it wouldn't take much less than about 6 to 9 months to get that. So if you're in a hurry, then having to seek clearance is not a solution. So by and large, the tendency is to try and find a means by which a particular scheme or proposal where aid is likely to be given rise to actually occur, is to try and find a means by which either to argue it's not state aid or indeed try and argue that it fits within one or other of the block exemptions. And that tends to be the approach that most parties take, because the timescales available and having to obtain clearance is not something that's very palatable. So what's the Commission done to try to remedy or deal with state aid in the context of the coronavirus? Well, the Commission, to be fair, acted very, very quickly and issued guidance on the 13th and 19th of March. There are powers contained within the Treaty for the Functioning of the European Union, the main book treaty itself, that allows the Commission to remedy a serious disturbance in the economy of a member state, And what they did is they relied on that provision to introduce an aid framework. So the Commission effectively said, well, so long as the schemes that you bring forward, and there has to be a scheme, so there has to be and that scheme must have a budget. As long as you come forward with a scheme, then you'll pretty much get automatic approval from the Commission. So this is actually a fast track authorization process. So this isn't falling within any of the block exemptions we've just discussed or trying to argue it's non-state aid. This is where we've accepted it's state aid, but we're fitting it within a framework that the European Union established. And the requirements for this scheme are that aid given per business must be less than €800,000. So I think that's roughly speaking about £700,000. That there's a formal scheme with a budget, so the government had to come forward, or a government had to come forward with an overall budget for how much it's going to apply for these purposes. And of course, because this is a temporary arrangement, the grants had to end by the 31st of December 2020. Now, of course, it may well be that some of these arrangements might have to continue for longer, because I think it's only now that people are beginning to appreciate how painful an experience the transition back to normality, whatever that is, will actually be. So it may be that actually some of these arrangements continue. But for now, they end on 31st of December. There is another scheme, or Part of the framework talks also about loan guarantees and loans at subsidised rates, but that's actually a far more complicated analysis, and I haven't really got time to go into that now, but it's just for the sake of completeness, it exists. Now, of course, where a scheme falls outside the scope of this particular framework, member states can ask or apply for fast-track arrangements to be considered quickly. So what they're doing here is they're saying, well, even if you don't meet this criteria, we may still allow you to do it, so long as, and you can submit those details, and we promise to look at them very quickly, far more quickly than we would perhaps have traditionally done so. Now, the sort of schemes that have been brought into force in the United Kingdom and brought into force very quickly were, of course, the Small Business Grants Fund. Interestingly enough, the guidance that supported this actually talked about businesses not relying on the new Covid-19 arrangements to allow up to 800,000 euros of aid, but rather to try and rely on the de minimis aid, the existing de minimis rules where those were available, which is quite interesting. And I'll explain probably why that was. Another scheme that's been widely publicised, of course, is the Retail, Hospitality and Leisure Grant Scheme, which, of course, very similarly allows up to 800,000 euros for supporting businesses in that sector. However, I think the most important of all the schemes is probably the one that was given approval on the 6th of April, which is called the Umbrella Scheme, which is open to local authorities quite specifically. Again, it allows for 800,000 euros per undertaking. I mentioned that I put a question mark after the word undertaking because I think it's sometimes not always easy to work out what an undertaking is for the purposes of the rules. I had one client contact me because he wasn't sure whether or not it meant 800,000 euros per shop premises or whether it was 800,000 for the whole business. So there's obviously some confusion sometimes. Basically, I think that's now been resolved, but clearly there's some confusion about what an undertaking is. And of course, the way in which the European Union approaches things is very different to the way in which others might approach it. So, an undertaking isn't necessarily a separate legal entity. An undertaking could in fact be a number of legal entities that are all connected in some way together. So it's far harder than it necessarily looks to work out precisely how much might be available when you just use a word like undertaking. One of the other issues I think that needs to be considered is that, of course, all of these schemes which are effectively coronavirus related insist that the entity that you're funding was not in economic difficulty or financial difficulties on the 31st of December 2019. One of the threads that runs through the general block exemption regulations is that it's a necessary prerequisite that the business is not in financial difficulties in order to receive aid. And this is one of the great principles of state aid. It shouldn't be used as a way of keeping businesses that are basically failing alive. And so consequently, it's not available for those purposes. It would be wrong, of course, to use this as a mechanism to keep a business that would ultimately fail, because that would be against the market. Businesses fail in markets, and that's how the sort of business cycle operates. The interesting contrast, of course, is with the de minimis regulations, because they actually make no reference to being in economic difficulty, and so therefore you can always have the 200,000 euros in any circumstances. So, of course, what it means is that where you can rely on the 200,000 euros, it might be better if, in those circumstances, you might not have been able to demonstrate that you were not in economic difficulty on the 31st of December. And when I use that term, not in economic difficulty, it is quite a difficult test to apply, and it's quite rigid in terms of how it applies, and it's set out in the general block exemption regulations, and there it sets out precisely what criteria you're supposed to apply for those purposes. Again, of course, like all these measures, it's time limited until the 31st of December. I should say 2020. I don't know why it says 2019, but anyway, 2020. So that takes up to the 31st of December 2020. Now I'm going to move on and talk about something completely different, of course, which is business tenancies. And this is really just a bit of a summary for those that aren't familiar in this area. As you've probably heard, very early on in the coronavirus pandemic, and the response, the government introduced measures very rapidly to protect tenants from having their leases forfeited by their landlords for non-payment of rent. Clearly, it was seen as a major concern that tenants could be effectively deprived of their premises for no fault of their own by virtue of business difficulties. However, interestingly enough, very, very quickly after that happened, companies or landlords attempted to use different measures to try to achieve the same result, and appreciating they couldn't forfeit leases, opted instead to serve statutory demands. Now, of course, the function of a statutory demand is to demand payment for a debt, and where it's not paid within a certain prescribed period of time, the serving party can then apply to have the business wound up, and in fact have business wound up so that they can extract the money that they're owed. Now, of course, this is something of a shot in the foot, really, for a lot of landlords. Because, of course, by winding up a business, then they're probably never going to get any rent. So, and that was the point at which a lot of tenants raised with their landlords and said, "Well, why are you doing this? Because fundamentally, you're destroying your own future income stream." But be that as it may, a lot of landlords were using this as a sort of last resort, because some of them felt that some of the tenants weren't paying when they should be, just because they didn't want to, and they were just using the law to stop having to do so. However, the government has now stepped in to stop the use of this measure in the Corporate Insolvency and Governance Bill, and effectively what the bill does is that it prevents an injunction being presented for a winding up petition. So effectively stops the first step in the process taking place. Interesting enough, the bill, although it's been in the offing for about a month now, has still not been or received royal assent. Currently, it's making its way through the House of Lords and will receive royal assent, I imagine, shortly, whether that's perhaps in the next week or so. However, interesting enough, the courts, in a way, have stepped into the breach, because what they've done is that they have been willing to grant injunctions to stop the presentation of winding up petitions, even though it's not law yet, on the strength of the fact that the government is about to introduce statutory mechanism to effectively stop the presentation of winding up petitions. So that's an interesting legal development, in the sense that the court effectively is making the law up as it goes along in anticipation of the law following. So that's an interesting approach. But anyway, what it's doing effectively is it's closing that loophole to ensure that tenants have the additional protection that not only can they not have their leases forfeited or taken away from them, but also that they can't be effectively forced into a form of bankruptcy in order for landlords to force them to pay the rent that they owe. So it's a very useful loophole for business tenants. Obviously, it doesn't help landlords, and you only have to look at some of the share prices of some of the shopping centre owners. I heard on the radio this morning, that Into shares have dropped from £3 a share to 7p in the course of the last 3 months, and Amazon shares have seen a similar slide. So clearly, ultimately someone has to pay for this. The question, of course, is to who has to pay. Moving on now to something again slightly different, electronic signatures. I wouldn't say an awful lot about this because I think a lot has been said in the last couple of months. I have to say, up until the coronavirus, I don't think anyone in the legal profession really used or thought about the use of electronic signatures. It simply wasn't something that they anticipated the need for. However, of course, because we're all operating from home and people having to operate electronically, it's become an issue that's becoming more and more important. And where we find ourselves now is that the Law Commission has made it very clear that you can effectively sign a document electronically and it will be perfectly valid. And there's no reason for that not to happen. Clearly, there are issues about wanting to ensure that you can track how that signature is recorded and ensure that it's fully valid. And there are software to help you do this. You can acquire things like DocuSign and Adobe Sign. They don't actually change the legal validity of what you're actually doing. All that they do is provide a sort of audit trail, so you can ensure that the processes, you can record that the fact that the decisions, that the signatures have been recorded on a particular date. So it gives you a kind of audit process which you can then refer to in the future if you need to. But it doesn't actually affect the fact that fundamentally you can sign a document with a typed details. You don't even need a written wet signature. You can in fact bring into force an agreement relatively easy. There is slight difficulty in the context of deeds because, of course, they usually have to be, or where they have to be witnessed. That would imply that you need to have someone present to witness the signature. Case law says you don't actually have to sign it at the same time as you witness it, as long as you witness the signature being presented. And also, of course, there is a suggestion or an argument that perhaps you could witness a signature by webcam. Now, I think the general consensus is that you probably couldn't, because the argument is that you should be present in the room at the same time, although the only case on the subject simply says that it's probably not possible to witness something by webcam. It's not actually been definitively resolved as to whether or not you can or not. So there again, that's an interesting possibility that goes into the future. One solution to some of these problems, of course, is to change the way in which you seal documents. So, for example, instead of having to have a witness, you could have two signatures. And I noticed one of the authorities I'm dealing with used to traditionally seal all of the documents with the common seal, which was witnessed in the presence of an authorised person. And now what the authority is doing is it's adopting a two-signature approach, which is very consistent with, say, the way in which a company signs and executes documents. Some of the other things that are happening at the moment, there are changes afoot around the way in which the courts are adapting to changed environments. I've been dealing with a case recently where everything has to be filed electronically now with the High Court. But the really big problem I think I've found recently is the whole issue around maximum data limits on submission of documents. That's really been a major issue. And also just generally dealing with the court. It's much harder. Having to put bundles together in electronic form and having to compress them has been a real challenge. But as I say, it's likely that these things are going to continue. And as I'll mention in a minute, I think it's likely that they'll potentially become more of that kind of online working. And this is the last topic I'm going to briefly touch on, which is virtual inquiries. Interestingly enough, on the 28th of May, the Planning Inspectorate published some revised guidance in relation to the use of virtual inquiries. And it said the following: we already have a programme of work in place to make better use of technology in how we work, including running events, hearings, examination inquiries in a virtual way using digital methods. And then it goes on to say the COVID-19 pandemic has substantially accelerated our work to do this. Now, what's interesting about that, of course, is that it underscores this point, which is that they accept, of course, that during the COVID-19 pandemic, they have to change the way in which they operate. Until very recently, it's much harder for site visits to be conducted and the like, which of course now can take place as of this guidance was being issued. But the point is that they were saying, what they're really saying is that this is just the beginning, that even after COVID-19 pandemic has ended, we will be looking more and more to the use of virtual hearings. And as they were suggesting, that their first virtual hearing was held on the 11th of May, and 20 hearings are due to take place in this month, along with 15 hearings of the for nationally significant infrastructure projects or development consent orders as well. Now, I have a particular interest in this because I'm myself involved in a compulsory purchase order inquiry, it's not clear at the moment precisely whether or not that sort of approach will be taken in that context. And one of the arguments that's used in the context of planning, of course, is that you simply have two parties by and large, and the public involvement is quite limited. Even it's said in development consent order inquiries, you have a limited number of participants, because it's argued that much of the proceedings are conducted on paper. It's largely a paper exercise. What's not clear is whether or not you have something similar, or whether the same approach could be taken to something that is more public in nature, something like a compulsory purchase order inquiry, which involves much greater public participation. Now, interestingly enough, the Ministry of Housing and Community and Local Government issued guidance on the 13th of May about compulsory purchase orders. It didn't say specifically that they weren't thinking about looking at virtual inquiries, looking at that as an option. All that the guidance really indicated was that there are certain parts of the service requirements, so for example, there's an obligation to place on deposit documents, could be dealt with electronically, because it was argued that the technical definition of somewhere where you kept documents for people to inspect could include online, so long as you told people that if they wanted to, they could receive hard copy by post. So there are some minor tinkering with the system, more about interpreting existing legislation, nothing about new proposals. And that's all. There is also talk in the guidance about acting in a more generous way towards parties to whom we're seeking to compulsory require, and also being more generous with time limits. But absent from the guidance is any talk, as I say, about virtual inquiries. And also, I think there's nothing in there about trying to make process slicker, to allow for more electronic serving the documents. One of the features of compulsory purchase order making is the sheer volume of documents that you have to serve when you come to issue evidence, for example, when you've prepared witness statements, you have to serve them on all of the objectors. That is an enormous task, and it's one area which I think could usefully be looked at as a means for streamlining the system, and whether or not you could introduce email service in those circumstances. But interesting enough, that has not been considered at this stage, and it's not, and I think that it should be as part of a wider review of some of the ways in which we organise and run inquiries. And it's a shame that it isn't, and it seems at the moment that compulsory purchase orders are sort of being kept to one side, which is probably of as much interest to local authorities as planning inquiries and the like, because of course a lot of authorities get involved in making and promoting compulsory purchase orders, and being able to speed up the process, reduce the amount of paper that's involved, I think would be very welcome indeed. Now that brings me to the end. I'm sorry that we overran slightly today. I will stop sharing, and Stephen, can you reappear? I don't know whether we have any questions. Hello? Any questions? I don't know how we're going to deal with them.
Okay. Go ahead, Kirsty.
If I was just going to say, if you click on the chat button, there's a couple of comments there.
Okay, sorry.
Attendees, feel free to ask any questions with Nathan and Stephen now.
I think that second one's for you, Stephen.
So I'm just trying to find the chat button. It's not the Q. Oh, here we are. Yeah. Okay. This is the one from Linda Durham. Yeah. There has been a change of law. We have a current contract commenced in 2019, not yet signed. Change in law calls operative from date of agreement. Obviously, agreement undated, can the clause be enforced? So, yeah, I think what this is saying that in the contents of leisure contract, it's being performed, but the wording in the contract hasn't been formally signed off. It's always a tricky question to know how to deal with a contract that's not been signed. The general advice is, frankly, if the parties are acting in accordance with the contract and that they're behaving in a way that you would expect by the contract, they're following the procedures set out within the contract, I think generally speaking, you would take the view that the contract is an agreed form document in effect, even though it's not been signed, and you have to assume that provision is valid and in effect in the absence of any evidence to the contrary. And it's just an administrative issue that the contract's not been signed. So I think probably, yes, I would take the view that you are stuck with it really. And as I said, that contract is fairly standard. That wording I talked about is fairly standard wording. So it's not that it was a specially negotiated term that was contentious. It's what all leisure providers would expect to see in their contracts. So yeah, I think unfortunately you're pretty much stuck with it. Don't know if Nathan would want to add anything on that.
No, I think that's right. I think I entirely agree, Stephen. Are there any other questions? Anyone popping up? I don't think so.
There is one question in the Q&A box.
Oh, okay. Sorry.
Hold on, let's have a look.
How would you deal with giving grants to domiciliary care providers, e.g. de minimis? Oh, right, okay.
That's for both of us, really, isn't it?
Yeah, it is. Yeah, domiciliary care does fall within SGEI. I'm always anxious about, and of course you have the SGI de minimis, which is much higher, which is €500,000 euros. So actually, it's a far generous measure. So if I could fit it within the SGI de minimis, then I certainly would. I'm not very enthusiastic about SGI generally because of the Commission guidance and the decision, which I think is actually quite difficult to apply.
I suppose a question as well, Melvin, that, sorry, Nathan, sorry, I think it's somebody else, is that a lot of care providers are quite large organisations. So, you know, would the de minimis work if you were to rely on that? Because increasingly care is being concentrated in the hands of a few very big organisations. So it might depend on whether you're dealing with a small local firm or a big firm.
Absolutely. I mean, you can, interesting about, I was dealing recently with the distinction between the decision and, of course, the case law, the outmark decision that sits behind it. And there is a sort of purist version of the application of the outmark decision, which means you don't have to comply or apply the decision proper. But it is, I think, quite a grey area, but it's used a lot for social care and housing and health. So I think there's scope to use it. You just have to use it quite carefully. But if, as I say, if I ever could squeeze anything into the de minimis threshold, especially as the SGI one is higher, then I'd do it. There's another question, Stephen. And when awarding a contract under Regulation 32, would you also issue a VEET notice? Subject close to my heart.
I'm not a big fan of VEET notices personally, because it kind of almost advertises to the big wide world that you are relying on something. There's no reason not to if you're comfortable that Regulation 32 does work in this situation. And I think at the moment it probably would. And I think you probably have to issue a contract award notice anyway once the contract is awarded, strictly speaking, although a lot of people don't. So I think my answer would probably be no, but I would issue a contract award notice.
Yeah.
Nathan, what's your view?
I'm slightly more optimistic about VEET notice, because I think if it's properly used, then you don't really have a huge amount to fear, and it does at least flush out potential opposition. I think Stephen's right though. If it was me, I would definitely serve a contract award notice as well afterwards. And Stephen's right, you ought to serve it anyway. Although technically speaking, if you say the rules don't apply, then maybe you don't. But I would definitely publish a contract award notice for the simple reason that it would reduce the limitation period afterwards as well to 30 days. And the other advantage of serving a CAN, I think, is that it probably would be harder to rule that it doesn't work. The problem with the VEET notice is you genuinely have to believe that it's valid. And so therefore you get into the whole issue about, you know, did the authority use it validly? Whereas a contract award notice, albeit you still have to identify why you're publishing it, is actually more of an administrative act. Now, there is a general consensus that it would be, and no one's ever tested it, that it actually be harder to challenge the use of a contract award notice because it's largely administrative, whereas a VEET notice is protective, and therefore it's going to receive far more scrutiny in terms of its use. So I would be inclined, if I was ever going to, well, in the future, if I publish a VEET notice, I think I'd be definitely keen to also publish a CAN notice as well, just because you would get the double protection, and also if one didn't work and they didn't take action within the 30-day period, then you'd have that protection as well.
Yeah, I see we've got a comment from Angela Kindness at Notts County Council, really on the previous point, saying that the MHCLG guidance on infection control says that they're relying on SGEI in giving the grant, which is, yeah, I think it's fair enough. I mean, I think, Angela, to be fair, what we have seen is where we've sought to rely on general exemptions like SGEI with various government departments who oversee these things, they tend to be quite sceptical about relying on a general thing like that, and would much rather you could rely on something quite specific. So, you know, that colours our thinking slightly. Oh, yeah. There's a comment from Sean. Yeah. Okay. Yeah. Well, as always, I suppose we ought to say that you know, there might be queries that people have about their own situation that they want to talk to us about individually. You can find us. Our telephones are diverted through to our home offices, so you know you can locate us, and we're always happy to chat with people.
Yes, that's great. Thank you all for participating and sticking with us, even though we had a few technical problems, some of which were down to me and unfortunately touching my screen, which seems to cause the slides to move on inadvertently. But there you are. I'll confess now, it's all me. Anyway, thanks very much, everybody, and thanks for taking part. And as I say, I think you'll be receiving the slides separately from Julie, but I'll make sure that happens. Thank you very much.
Okay, bye.
Bye.